Once a prima facie claim has been made of self-defense at a pretrial immunity hearing, the burden of proof by clear and convincing evidence is on the party seeking to overcome the immunity. Of course, that party is always the state from criminal prosecution under the Florida Self-Defense Immunity Statute. Now, what do we mean by prima facie case? So a prima facie case is basically a more than zero evidence in support of self-defense. So if you have zero evidence in support of self-defense, well, then strictly as a technical legal matter, your conduct can't have been self-defense. Self-defense has very particular elements. By the way, if you're not familiar with those elements, you can get them here. They're not a state secret. We believe we invented this paradigm of these 5 elements of self-defense, but we share them happily with the world. You can get these for free. This is just a PDF download, an infographic of the 5 elements of self-defense. Those elements are innocence, imminence, proportionality, avoidance, and reasonableness. The infographic lists them and provides a brief description, a few sentences of each one. These are the building blocks of a claim of self-defense, folks, and these are cumulative and required, meaning if any one of the required elements is missing, meaning there's zero evidence in support of it, or the finder of fact doesn't believe the evidence in support of it, if any required element is missing, your privilege of self-defense isn't just reduced or mitigated, it's eliminated. Self-defense as a legal defense is like a light switch, folks. Either you 100% qualify and you have zero legal liability for that use of force, or you 0% qualify. You have 100% legal liability for that use of force. And the building blocks of whether or not you do qualify, the check boxes, are these 5 elements of self-defense. So if you're not familiar with these 5 elements of self-defense, folks, I urge you at the very least, get this free infographic. Does not cost a penny. And you can get that at lawofselfdefense.com/elements. Lawofselfdefense.com/elements. By the way, if you're an instructor, have a classroom, you'd like a poster size of this infographic, we also have those available. Those are not free. Obviously, we need to print those and ship them. But if you're interested in a poster size of this, you can also get that at lawofselfdefense.com/elements. But if all you want is a PDF download, totally free. And if you don't understand these 5 elements, you can't possibly understand how use of force law works. So I would urge you to get that at lawselfdefense.com/elements. So the prima facie case is you have to first show up in court with more than zero evidence on each of the required elements of self-defense. Now, I mentioned the 5 elements. There's up to 5 elements. That's the maximum number. That's good news. There's not 500 check boxes for self-defense. There's not 50 check boxes for self-defense. There's only 5, up to 5. There are circumstances in which not all 5 elements are required. So, for example, in a stand your ground state, normally the element of avoidance deals with whether or not you had a legal duty to retreat before you acted in self-defense. Normally in a stand your ground state, in an otherwise lawful act of self-defense, avoidance is not required. If avoidance is not required, you only have 4 elements you have to worry about in your claim of self-defense: innocence, imminence, proportionality, and reasonableness. So it's not always the case that all 5 elements are required, but the good news is there's only up to 5 elements required, and those are in that infographic. So for this prima facie case in Florida, let's assume avoidance is relieved here because of Florida stand your ground status. You have to come up with more than zero evidence in support of each of the 4 remaining elements of self-defense: innocence, imminence, proportionality, and reasonableness. Once you have more than zero evidence, you've met your prima facie burden. If there's zero evidence on any of the required elements, then strictly as a technical matter, your conduct cannot have been lawful self-defense because you didn't check one of the boxes. The moment there's more than zero evidence, however, there's something for the finder of fact to consider in determining whether or not that required element has been checked. So that's the test here, meeting the initial test. Before you can argue self-defense in court at all, you have to be able to show there's more than zero evidence in support of each of the required elements. That's what this prima facie claim is. And what the order is pointing out here is that once the defendant has done that, shown more than zero evidence, maybe not a lot, but more than zero evidence for each of the required elements of a claim of self-defense, in this pretrial hearing, once the defendant has met that burden, then the burden of proof on self-defense shifts to the state to have to disprove self-defense by clear and convincing evidence. If the state can do that, your request for self-defense immunity is denied. If the state fails to meet that burden of disproving self-defense by clear and convincing evidence, then the hearing judge is supposed to grant your request for immunity. You're no longer subject to prosecution. You're no longer subject to civil suit for that use of force. Now, the judge here references immunity from criminal prosecution provided under Florida statute 776032, and then he reads a relevant portion of the statute. So the relevant portion is: a person is justified in using or threatening to use deadly force. See if I can get this to bold. If he reasonably believes that using or threatening to use such force is necessary to prevent imminent or great bodily harm, imminent death or great bodily harm to himself or another, or to prevent the imminent commission of a forcible felony. A person who uses or threatens to use deadly force in accordance with the subsection does not have a duty to retreat, has the right to stand his or her ground. That's the stand your ground language there. It's not a separate statute. It's just embedded in existing Florida self-defense statutes. And it did not used to exist. So this was the language that was added when Florida became a stand your ground state. Has the right to stand his or her ground if the person using or threatening to use a deadly force is not engaged in criminal activity, and is in a place where she or he has a right to be. So this is basically setting out the elements of self-defense and noting that avoidance is not required in an otherwise lawful case of self-defense. So you have to be facing an imminent threat, right? That's the element of imminence, against some unlawful use of force against you. The force needs to be, if you're going to use deadly defensive force, the force you're threatened with has to be death or great bodily harm. That's proportionality. You have to reasonably believe. That's the element of reasonableness. Forcible felony, again, that means the other party's the aggressor. You're the innocent victim of their forcible felony. That's the element of innocence, once more. And if you meet these elements of self-defense under Florida law, you do not have a duty to retreat. So they're saying the element of avoidance is off the table if you meet the conditions for having avoidance taken off the table. So it's very common for statutory stand your ground. Not all stand your ground in every state is statute-based. California is a very strong stand your ground state. You might be surprised to hear that, but they are. They have one of the most robust stand your ground provisions in all the 50 states. California does. But you won't find a California stand your ground statute because California stand your ground law is not in statute. It's in case law. It's in court decisions. And case law is just as viable law as is statutory law. And in states that are stand your ground by case law, typically it's just a blanket relief of a legal duty to retreat. In states that are stand your ground by statute, normally when a statute is created, there's debate and compromise and conditions are added. That's the nature of the sausage making of the legislative process. That happened here in Florida. So you don't automatically qualify for stand your ground in Florida. You have to meet certain conditions. Those conditions include not being engaged in criminal activity and being in a place where you have a right to be. If you meet those conditions, you qualify for quote unquote stand your ground. You're relieved of that element of avoidance. So these are essentially the elements of self-defense that have to be met under Florida law. The statute, the order continues, and case law, meaning court decisions, appellate court decisions, reveal a multi-step analysis of self-defense immunity. The defendant must, and again, here it's really just stepping through the elements of self-defense, must reasonably believe using such force was necessary to prevent imminent death or great bodily harm, or to prevent the imminent commission of a forcible felony. Now, here's one interesting thing here. I mentioned that stand your ground in Florida has conditions. You have to qualify for stand your ground. You have to qualify for being relieved of a legal duty to retreat, being relieved of that element of avoidance. And it's right there in the statute. We just looked at it. You don't have a duty to retreat. You can stand your ground if you meet these conditions, not be engaged in criminal activity, being in a place you have a right to be. The Florida courts have decided that those same conditions apply to a different legal doctrine, self-defense immunity. Remember, I talked earlier, stand your ground is one legal doctrine. Self-defense immunity is a completely different legal doctrine. In fact, self-defense immunity has its own statute, 776032. And that statute says nothing. The self-defense immunity statute says nothing about not being engaged in criminal activity and being in a place you have a right to be. So my reading of the law would be that, yes, those conditions have to be met to qualify for stand your ground, for being relieved of that legal duty, that legal element of avoidance. But self-defense immunity does not have those conditions. Of course, I'm not in charge of things. And certainly the Florida legislature did not put those conditions into the self-defense immunity statute. But this is one of the reasons that just relying on the plain English reading of a statute, the apparent plain English meaning of a statute, can be so dangerous, because the Florida appellate courts have decided to read into the self-defense immunity statute conditions that are not in the statute. And those conditions are the same conditions that apply to stand your ground, that are in the stand your ground statute, but are not in the self-defense immunity statute. But the Florida courts say, no, we're going to pretend that self-defense immunity has those same conditions. Why? I don't know. I think that's bad law. I think the courts are wrong. This is a faulty interpretation of self-defense immunity law, but it is the interpretation that the courts will apply, because the trial courts and these hearing courts apply the law as the appellate courts tell them to. And the appellate courts have told them, as far as we're concerned, not being engaged in criminal activity and being in a place you have a right to be are conditions of self-defense immunity, even though they don't exist in the self-defense immunity statute. So, again, it's a pet peeve to me. I think that's bad law, but it is the law as it exists in Florida. So my point really here is, if you go read the self-defense immunity statute, you would not know this, because these conditions are not in the self-defense immunity statute. So if you take a CCW course, a self-defense course, a concealed carry permit course, and they get to the legal part, and all they do in the legal part is read you some statutes, you would not know from the reading of the self-defense immunity statute that these are conditions of self-defense immunity, because they're not in the self-defense immunity statute. The only way to know would be to also know the case law. And folks, if you've read your state self-defense statutes and you have not read the case law that interpret and apply those statutes, you don't really know what the statute means, because just like here, the statute does not necessarily mean what it appears to mean. It does not necessarily mean what the legislature intended it to mean. It means what the courts that interpret and apply those statutes to real people in real cases say it means. And what they say it means can be quite different than the apparent plain English reading of the statute. So be cautious about relying simply on statutory language. So we continue